Welcome to the Growth Matters podcast. My name is Justice. We talk about business, technology, and personal growth and development. So enjoy, sit back, and relax. The Growth Matters podcast covers many elements such as how we can grow in our faith, family, finances, and friendships. In addition, we cover topics such as current events. But today's episode is talking about employment law. We have in the studio with us Julian Tynes, an attorney and former Assistant Secretary at Massachusetts Department of Transportation, Office in Diversity and Civil Rights. Welcome to the Growth Matters podcast.
Thank you, Justice. Thank you so much for inviting me.
Yeah, we're glad to have you. Could you share just a little bit about yourself with our listening audience?
Sure. As you stated, I'm a labor and employment attorney. That's actually my second career. I was a school teacher and became a labor and employment attorney. I'm admitted in both the state of Massachusetts and the state of Connecticut. In the state of Connecticut, I worked for a labor union, a public sector labor union that represented police officers and public sector employees, municipal employees. And then I started working for the Commonwealth. I've worked for the Executive Office of Health and Human Services as Labor and Employment Counsel. At one point in my career, I was at the MCAD as a commissioner and the chair. And at Mass DOT, I was Director of Labor Relations and Employment Law. And then from there, I went to the Office of Diversity and Civil Rights, where I was the Assistant Secretary for Diversity and Civil Rights, and I was the Chief Diversity Officer for MassDOT and the MBTA.
Oh, great. So you got a wealth of experience and knowledge in this area. So why don't we just go right ahead and get into this conversation?
Sure.
What are the basic U.S. employment laws in general, if you will?
Well, the first thing we have to realize is many employment laws are determined by state.
Mm-hmm.
But there's certain things that are the bedrocks of employment law. One of the things is, and most people don't realize it, is one of the black letter areas of law is that basically everyone, unless you're in a collective bargaining unit, something of that nature, is an employee at will. An employee at will, meaning that you serve at the will of the employer, that they can let you go. They can let you go for a good cause. They can let you go for no cause. What they can't let you go for or fire you for is illegal cause. Now, people might say, okay, what is illegal cause? And that's where we go to the next thing. And those are the civil rights statutes, for example, that protect people from discrimination.
Okay.
So, for example, the Civil Rights Act right now was signed in 1965. So it's coming on its 50th year. It will be coming up soon. Or 60th year, 59th year. It's in its 59th year. And so, for example, under Title VII of the Civil Rights Act, you can't discriminate against a person based on their race. You can't discriminate against them based on their gender. You can't discriminate against someone based on their religion. You cannot, under the ADA, discriminate against a person based on their disabled status. And there's other areas too, but for example, you can't discriminate against that. And also, because of the civil rights protections, you can't discriminate against a person, for example, because they file a claim in that area or because they're a witness in that area. The other protections that we have, for example, there's the Family Medical Leave Act. And so under the Family Medical Leave Act, if a person has worked the minimum of 1,250 hours in the previous year and their employer is above a certain size, then they are able to, they are eligible for an unpaid leave to go and care for an immediate family member with a serious medical condition or for their own serious medical condition. Serious family member being their parent, being their child, being their spouse. And a lot of times people get confused by that because they want to know, well, What about my mother-in-law? Well, your mother-in-law is not your parent.
Okay.
Your wife would be eligible for that, but they're not your parent. There are exceptions where somebody stands in the place of a parent, loco parentis. For example, let's say someone who was raised by an aunt because something had happened to their mother when they were young, or an uncle, right? So another family member raised them, and that person later became sick. They could go present that evidence, they could show that the documentation that was raised by this person, so on and so forth. And then they would stand in the place of that person. And it's not limited, for example, to birth parents. And the reason I say that, let's say someone is adopted by someone. Well, they would have the same legal rights as a child that the person was their birth parent. And so, like I said, your child, your parent, not your grandparent, your child, your parent, your spouse, their serious medical condition or your own. So the other thing is people have to realize it does not apply to your siblings, because people automatically assume it applies to their siblings. And the other thing is people wonder, well, how do I show what a serious medical condition is? Well, to a degree, that's defined by law. And when you're applying for FMLA, you have to get medical documentation from your doctor. Now, your doctor's information does not have to, per se, state exactly what the condition is. What it does have to show is that they have to state that you have a serious medical condition that either you require time off or you're required to care for this family member.
Okay, that's very good information, especially knowing that it's your spouse, your parent, or your child that you can only really that falls under that.
Or yourself. Now, the thing people have to remember is you have a total of 12 weeks. So, for example, you don't get 12 weeks for your spouse, an additional 12 weeks for your parents, additional 12 weeks for yourself, an additional 12 weeks for your children. You have a total of 12 weeks in a calendar year.
Okay.
And sometimes people get confused by that because, for example, let's say they have a parent with a serious medical condition, right? And so they get the FMLA paperwork and they get it granted for that. Then something happens to them. One, they still have to apply for FMLA. They don't just have it blanket. They have to show that they have the serious medical condition. Or if it's for their spouse or whoever, it's just not for the original person. The other thing is the time that they have available is what is remaining of the 12 weeks. They don't get a new 12-week period during that calendar year.
Yeah. Okay. That's good to know. So, for instance, this calendar year is 12 weeks. But if that's the same person they were caring for originally in 2025, that become a new 12 weeks? Is that how I understand it?
It would be, and they would have to also go and submit paperwork for the upcoming year, the next year. Now, the thing people have to be aware of, even if they're applying for the next year, is under the federal law, you have to have worked a minimum of 1,250 hours. There have to be 1,250 work hours the previous year for you to be eligible. So, for example, let's say a person uses it 12 weeks, right?
Okay.
And let's say they've also, there's holidays where they don't work, right?
That's right.
And let's say that they've also had a lot of vacation time and they just decided to use their vacation time. At the end of that next year, when that next year comes up, they may not have the actual 1,250 hours worked because it has to be, you had to have actually worked 1,250 hours. So sick time, vacation time, holiday time, none of that counts toward it. It's got to be 1,250 hours worked.
Okay.
So that's something people have to be aware of also.
But I'm glad you brought that point out because some people may not even be aware that they need to work the 1,250, and just like you said, vacation, holiday, sick days are not included in that 1,250 hours.
Yeah. And I think it's easy for people to assume that because, for example, they're looking at their paycheck or they're saying, hey, no, but I got, this was vacation time, paid vacation. So they think it counts. It doesn't count. You weren't working during that time.
Okay. And I know you just spoke for a broad sense, for as far as the U.S., but what about the right to work law in Massachusetts?
Well, let me explain. In Massachusetts isn't what's called a right to work state.
Okay.
And in some ways, that's a good thing because a lot of times people hear right to work state. It sounds good. But actually, right to work is the fact that if there's a union, people don't have to join the union. They don't have to pay the union dues. And so right to work states were originally put in as a response to the NLRA, the National Labor Relations Act. And if you'll notice, if people would look on a map, look it up sometime, Google, and notice a map of states that are right to work states, they will notice that many of them, they tend to be in the South. They tend to be in states that are not supportive of union rights. And I'm not saying this as a proponent of union rights or not a proponent, but what I'm saying is that one thing you'll notice is in many right to, quote unquote, right to work states, the income level tends to be lower overall because for many of these type of jobs, for example, that's why for many of us growing up in the United States, the auto industry was centered in Detroit, Michigan.
Yeah.
And one thing we've noticed over the years, and in some northern states, one thing we've noticed over the years is we look and we say, wow, they built a plant in Alabama. These foreign countries. They built a plant in Georgia. They built a plant. Well, that's because these are right to work states. And so the people who are working there are not necessarily members of the United Auto Workers, for example.
Okay.
And because of that, for example, it impacts not only because it's one thing when an employer is negotiating with a union, but if they're not negotiating with the union, there tends to be lower salaries. The benefits aren't the same. It could be on everything from healthcare benefits, vacation time, so on and so forth. And so it's really the term right to work state is really, how can I put it? It really doesn't accurately portray what the name says.
Okay. It's a little misleading then.
Yeah, it's misleading.
Okay.
I mean, I can understand they're saying that people shouldn't have to join a union, so that's fine. People can always be an agency fee payer also. People in states where there's a union. But the thing is, by doing that, for example, they don't have the same authority. They don't have the power. Or the workers, the employees don't have the same power to go and work together, to organize together, to ensure, pay and working conditions.
Could you explain a little bit more about the agency, the fee?
Oh, the agency, what happens is if somebody's you can be in a bargaining unit and you can choose instead of being a bargaining unit member, instead of being a union member, you're still a bargaining unit member, and you pay what is called an agency fee. And the agency fee is simply, the union can only charge you for the cost of representation. And if you say, well, what is the cost of representation? One, the cost of negotiating the collective bargaining unit. Two, within the collective bargaining agreement, there are certain things, for example, there may be a just cause provision. There may be parts of the provisions in this collective bargaining agreement that goes toward, for example, seniority provisions, in regards to overtime, in regards to promotional opportunities, so on and so forth.
Okay.
And it may even, or for hires, it may have that. It may have the processes used to ensure that people are treated fairly. Well, everyone in the bargaining unit is protected by that language, even if they're not a union member. But agency fee payers pay only for the cost of representation. Now, the downside to that is they pay less, but the downside to that is, for example, agency fee payers, because they've chosen not to be a member of the union, but just to simply pay the agency fee, they're not allowed to vote in union elections. So they're having the representation, for example, but they can't necessarily go and decide, well, who's going to be my local president? Who's going to be our union steward? They don't have that vote.
Oh, okay. Wow. So it's really a downside by not being part of the
Yeah, but
agreement.
People have different reasons why they choose. People have religious reasons why they don't join unions.
Mm-hmm.
Some people have reasons, for example, political reasons. They might not agree with the union's support of certain candidates.
Okay.
Or they don't want it used, the union money used for political purposes. And so they're paying so that they're saying, hey, I'm only paying for representation. I'm not paying to give money to this candidate or that candidate. I'm not paying, for example, on controversial issues that the union may take a stand on, a position on, that the person doesn't necessarily agree with. Political issues, like I said, religious,
Mm-hmm.
things that may impugn on their religious beliefs. And so, people have various reasons why they choose not to join the union and become agency fee payers.
Oh, okay. Do you see quite a bit of employee rights being violated in today's workforce?
I wouldn't say I see a lot. I would say that it still occurs.
Okay.
And I think that, and I would also say that many times people don't know initially who they should go to. For example, if someone's in a collective bargaining unit, they're in a union, and there's a question that comes up, either a question of, let's say they're being disciplined for something, or they believe that they should have gotten a promotion and they didn't get the promotion, right?
Okay.
I'm just using those as examples. There's other things that are in collective bargaining agreements, but a lot of times what people will do is they'll want to go hire a private lawyer, right?
Mm-hmm.
Many of those things are specifically addressed in the collective bargaining agreement. And the union is the exclusive representative of the bargaining unit members on those matters. So initially, they should probably go to their union to see if there was a possible violation of the CBA.
Okay.
That will happen. Sometimes another thing that happens is, for example, in regards to civil rights, people will they'll feel they're being treated differently, or they were treated unfairly, and they will want to file a discrimination complaint, right?
Okay.
But what they have to show and realize is that discrimination, for example, is not that I was treated unfairly and I'm female, or I'm black, or I'm disabled, or I'm gay, or or I'm Catholic.
Okay.
It has to be I'm discriminated against because I was. And you have to show the connection between the discrimination and your protected class.
Okay.
And many times people don't realize that. They think that it's, well, I'm this, so I'm protected. You're protected against being discriminated against because of it, but the burden is on the employee who's alleging that to show, hey, this is how I was being discriminated against. This is why I believe it. I was being discriminated against because of my protected class status.
Mm-hmm. Okay. So you really have to have things lined up.
Yes.
Okay.
You have to have things lined up. And you really have to be able to show that. And I'm not saying it's a common thing, but I'm just saying that it's something they're not aware of that. People aren't aware, for example, a person who has a disabling condition, many times they're not aware of their rights to what's called reasonable accommodation under the American with Disabilities Act. And what I mean by that is, and it happens many times, especially as we age,
Mm-hmm.
what happens is sometimes our body breaks down. It can be a back injury. It can be, muscular skeletal. It can be different things. For example, under the ADA, heart disease can be a disabling condition. Diabetes, depending on how bad you're affected by it, can be. Cancer, so on and so forth.
Okay.
But a lot of times people, they are not aware of their rights to ask for a reasonable accommodation. And they don't even think about, well, how can I be accommodated? For example, people will have a back injury and they'll have a lifting limitation, right? And so the question, and let's say the job requires some ability to move certain things, right?
Okay.
Well, the question is more, how can it be accommodated so they can perform what's called the essential functions of the position? In other words, every job title has certain essential functions everyone has to be able to do, right?
Yes, correct. Okay.
And so, for example, in some settings where there's been a lifting requirement, the reasonable accommodation is just a device that helps them lift the thing so it can be moved. Because the idea is more that the lifting requirement is there so it can be moved.
Mm-hmm.
More than because they just want you to be able to lift something. The same idea, for example, let's say that there's a requirement for a valid driver's license, right?
That's right. Okay.
One, driving would have to be an essential function of the position, right?
Mm-hmm. Okay.
And then from there, you'd have to see, is it actually driving or is it the ability to get to certain locations and within a timely manner?
Okay.
And the reason I'm saying that is, for example, like Boston has, people complain about the T, but it has a pretty good transportation system, right?
Mm-hmm.
So for some jobs where they say that, the question may be like if they say, oh, we need you to be able to get to this office or that office. Well, the question is, okay, can you get there through public transportation? Can you get there through Uber? If that can be achieved, that's the important thing.
Okay.
But the main thing is being able to perform the essential functions of the position. And, there's various accommodations. For example, sometimes people may be vision impaired. And so they may have a computer screen that goes and assists with that.
Yeah.
It depends on the disabling condition. And then the idea is to go look and see, okay, the person would go to depending on their employer, the HR representative for ADA accommodations, or some employers have an ADA coordinator, so on and so forth, and they would apply for reasonable accommodation. And then the idea is to see, okay, can this be accommodated, and how can it be reasonably accommodated? Mm-hmm. And again, the term is reasonable.
Okay.
because it has to be something that's reasonable.
So far as they need maybe an ergonomic chair, if they have
Yeah,
carpal tunnel,
that's
those
an
kinds of things.
excellent example.
Okay.
And as like for example, um, at Mass Dot a few years ago, because there was a time when there was a really big demand for the desk that could go up and down.
Yes. Uh-huh.
And what happened is what they did for a lot of the desk and a lot of the cubicles, they put it in where they could automatically, the person could move it themselves. It could be moved up and down instead of having to get a separate piece.
That's
And
good.
so, yeah, they did that so that it'd make it for people easier to accommodate. And for example, even I think we're all familiar in office places where people will have special mouses or special things for that because they have carpal tunnel syndrome.
Mm-hmm. That's right.
So those are all examples of reasonable accommodations
Issues.
that people have.
Mm-hmm. Oh, okay. Well, this is some good information for people to know, especially those reasonable accommodations. Any other, what would constitute a hostile work environment?
Well, I will say this. A hostile work environment is how the person is treated. But the question is, what is the hostile work environment based on?
Mm-hmm.
So in other words, in theory, it could be a hostile work environment, but not be actionable. For example, you may have someone someone may have a supervisor, somebody who heads a unit, who's just rude to people,
Okay.
speaks ill, doesn't curse at them, but it isn't a pleasant place.
Mm-hmm.
That may not be actionable. However, if the hostile work environment is based, for example, on race, if there's jokes, if it's based on sex, it's sexual harassment, for example, based on a hostile work environment, where, for example, let's say that it's been traditionally a setting where mostly males worked, right?
Mm-hmm. Okay.
And a female's coming to work there, and people have pictures up of women in bikinis or those type of things. That can be considered a hostile work environment. If a person of color comes in and people are either saying things about people of color, there's statements being put up. I know that there's been places, for example, in the past where it's been alleged and it's gotten numerous media attention where people have done things like they found a noose in their workplace. That's a hostile work environment based on race.
Okay.
Or, for example, and I think this would be hostile for a lot of people, you come into the workplace and there's a swastika there. Somebody puts a swastika at their desk or on their wall or something.
Mm-hmm.
That's a hostile work environment.
Right. Okay.
It's based on protected class.
Mm-hmm.
That's something that's actionable.
Okay. Oh, okay. What is the Fair Employment Law in Massachusetts? Is that such a thing?
Well, would you repeat that, please?
What is the Fair Employment Law in Massachusetts?
I don't know. I don't believe that it's so much the Fair Employment Law per se.
Mm-hmm.
There's a series of laws in Massachusetts that all employers are required to follow.
Okay.
And there's certain protections for employees. And so in that sense, there's a series of employment laws. And just like in other states, there is a series of employment laws that employers are required to go and adhere to.
As far as hopefully good working conditions
right.
Okay, safe conditions.
Safe conditions. I mean, and the thing is, there's multiple agencies that oversee that. So, for example, one of the things we'll hear about sometimes is OSHA
Yes.
office. And so OSHA, that's their responsibility, safety and health, and they will come in and they will examine working conditions. Now, generally, sometimes it will be in an office setting, and that will be where, there'll be media attention on it because all of a sudden you'll find out that in the building itself was unsafe, and there's fumes in the air and different things like that.
Okay.
But generally, when you read about OSHA conditions like that, it's generally in factory settings, and especially it gets a lot of media attention in the meat packing industry and chicken processing industry, where you'll find out and they'll go and shut down a plant, or they'll come in and they'll look because of the conditions that people are working under. And they'll look at everything from the cleanliness of the place, the floors, the temperature in the place, all types of things. But
okay.
yeah.
Oh, so do they do those kinds of inspections on a yearly base, or somebody complain?
Don't generally. Those will happen when someone will complain.
Okay.
But what will happen is, for example, let's say if it's let's say people in the building are getting sick and no one can understand what's going on, right?
Okay.
And people are getting seriously ill. And there may be a complaint filed, and they may come in and they may check the ventilation and find something there. So it's that type of thing.
Okay. So yeah, and OSHA, and I noticed like for OSHA, for like construction, when there's
construction. Yeah. And they cover a wide range of workplaces. But yeah, for construction especially, because obviously a construction site or a warehouse can be a very dangerous place. And so they want to make sure that the proper things are in place, because, if the proper things aren't in place, people can be very badly injured or even killed.
Yeah, because you can hear, you see that with scaffolding and things of that nature. And,
right.
And buildings are going up, and they come right in, and they shut the whole operation down to do the investigation. Okay. Well, that's really good. Anything else as we wrap up and conclude this episode that you like to share about employment law in general, or just to give some tips to employers as well as employees? Well,
I think that one of the things that's important for employers to remember is, one, they should know what those laws are or have somebody who could advise them on them, and the importance of compliance. I think that's really important. And for employees, I think a big thing is knowing their rights, knowing the benefits, knowing who the people are that they're supposed to contact when certain things occur. For example, knowing that when there's a family medical emergency, knowing the type to knowing, okay, should I go to HR for this? If my mother is going to need my care 2 days a week for me to go take her to dialysis, right?
Okay.
Knowing that I have to go to HR, knowing that I'm going to have to go to her doctor, and we're going to have to I'm going to have to ask for family medical leave for my mother's condition, and realizing that this is strictly for her condition for this. So, for example, you may have FMLA for a family member for a certain condition. Another condition comes up with that family member. You don't automatically have FMLA for that. You have to show that this other condition is also a serious medical condition that requires your care.
Okay.
But just knowing those things, I think that's really important. And also knowing that if they do suffer a disabling condition, knowing who to go to request a reasonable accommodation. And if they're in a union, knowing who their union is, who the union reps are, who the steward is. So if there's questions on things that are in the CBA or questions on things in the workplace, they know who to go to.
Would you also ask them to, they should read the collective bargaining agreement as well, huh?
I think so. And I think that there's two things. Many employers, when people are hired, people will get a copy of the CBA or they'll have a copy of it online, and the union will give it to them also. And I think it is important for people to go look at the CBA. I think that by looking at the CBA, they have an idea of what the rights are, and how the process works for things.
Yeah, and I mean, because some of those contracts when they negotiate those agreements, they're some more times 3 or 4 year agreements. So
they're generally multi-year. They're not going to go year to year.
Mm-hmm.
And the other thing is, because it's important for people to realize that, because for example, when you're in that union, you can't say, for example, I know me and him do the same job, but I think I should get paid more. The salary range is determined by factors in the union contract for a job title. So they'll look at things like seniority, things of that nature.
Mm-hmm. Okay.
And so people need to go and know their CBA so that they know even things like that. How is that determined?
Yeah. And how you acquire vacation time, sick time, all of those.
Right. How it's computed, and knowing that, it's not something where you can just walk up to your boss and say, if you're in a union, hey, I want a raise. It doesn't work that way.
Yeah. And understand the process. Yeah. Okay. Good. Well, I want to say again, thank you, Julian Tynes, for being our guest on the Growth Matters podcast and sharing insights on employment law. It's been very valuable information that you shared with us. Thank you for listening to the Growth Matters podcast. You know what to do. Like, subscribe, comment, and share with the broader community. Until next time, stay focused, prepare, execute, and celebrate the victories as you continue to grow and develop in every area of your life. I will see you at the next one. Peace. I am your host, Justice.